Good morning. This is Orly Taitz, and this is Taitz report for February the 19th, 2014. I wanted to provide the viewers with information in regards to two cases that I'm currently working on. And the first thing that I wanted to mention is the fact that I am running for AG in California. You can get all the information at taitzreport.com, Taitz report.com. I am submitting tomorrow the nomination signatures. If you can sign the nomination, it is appreciated. And what is important that if I am a candidate, I will be able to publish a candidate statement, which is read by 40 million people in the state of California. And that's a great opportunity for me to provide all the information to the public on the issues that are being censored by the current establishment. Second, I wanted to provide information in regards to the case that I'm currently working on, and it's a motion for summary judgment that I requested in my favor, and that's in relation to a case of Taitz v. Colvin, and that's a case against the Social Security Administration in regards to application by one Harry Bunnell to Social Security number 042684425. What is important is that Barack Obama fraudulently used that Social Security number, posted it with his tax returns, and when the number was checked, it failed both E-Verify and SSNVS. We have a criminal sitting in the White House who is using a bogus Social Security number. Incidentally, he also was not able to sign up for his own signature program, ACA, and I'm guessing specifically because he's using bogus IDs. In this case, I provided some documents. One of them here, this is the document, and that's the letter. I'm using it here close to the camera. This is a letter that was signed by Dawn Wiggins, an officer of Social Security Administration, where she actually found the records for Harry Bunnell. Originally, she refused to provide them, claiming privacy, and later she claimed that she couldn't find the records. Here, I'm also providing as an exhibit, this is SS5, and here it is close to the camera. SS5, it's actual application that a person submits to Social Security Administration, and this one is the SS5 for one Thomas Wood, and that's the gentleman who got a Social Security number right before one that is fraudulently being used by Obama. His number is 042684424. This is a certification that goes with application. And what I'm showing now, this is Numident. Those are pages of computer record. And Numident is not the same as actual application. So I'm trying to show it to the public so the public is informed of what is happening and what is going on. So without much ado, I'm going to the actual case. So this is the opposition to motion to dismiss by the defense, and also it's a motion for summary judgment that is filed by me, the plaintiff. History of the case. This case revolves around SS5, Social Security application for Social Security number 042684425, which was issued to Harry Bunnell. This request is extremely important as President of the United States Barack Obama posted his tax returns online on whitehouse.gov and originally did not flatten the PDF file. The Social Security number that he is using became available to the public and it failed both E-Verify and SSNVS, showing that the President of the United States is using a Social Security number that was never assigned to him. Subsequently, investigator Albert Hendershot found in Mervin's Information Systems database that the number in question was issued to Harry Bunnell, who according to 1940 census was 50 years old in 1940. Therefore, he was born in and around 1889-1890. On November 6, 2012, Social Security and Freedom of Information Act Officer Dawn Wiggins responded to FOIA request and filed information application for SSN for Harry Bunnell. However, she refused to release it due to privacy concerns. Plaintiff Orly Taitz sought release of the record based on 120-year rule of SSA, which states that SSA has to release SS5 of extremely aged individuals who are 120 years old or older, even if the SSA does not have the consent or proof of death of the subject of the request. SSA did not respond for over 60 days, even though it was obligated to respond within 20 business days. Taitz filed a legal action at hand. After the legal action was filed, SSA responded claiming that they cannot find the affirmation record. This court gave the plaintiff a leave to file a second amended complaint in light of the fact that SSA responded. However, response did not show that a proper search was done. Plaintiff filed a second amended complaint. Defense filed a motion for summary judgment in favor of defense, claiming that defense could not find the requested document. Defense based their motion for MSJ on affidavit of the same FOIA officer Wiggins, who previously found the document in question and who claimed that this time she could not find it. Wiggins, through her affidavit, admits that she only looked at Numident electronic record and never even made any effort to look at the actual paper record, never even looked at the actual original application. Plaintiff is seeking a summary judgment in favor of plaintiff, and as defense admitted that it did not even search for the original SS5 application. Argument. Defense did not deny and therefore admit that they violated FOIA and did not search for SS5 paper record and instead only searched for a Numident. In U.S. versus Edwin Wilson, Judge Lynn Hughes reversed and vacated Wilson's conviction and wrote in pertinent part at page 809. Honesty comes hard to the government. Don't we know that? The court should deny the motion to dismiss motion for summary judgment in favor of the defense and grant the motion for summary judgment in favor of the plaintiff, as in her third amended sworn affidavit submitted with her motion for summary judgment. FOIA officer Don Wiggins admits that she never performed any search of the actual original SS5 Social Security application, which was requested and which she was obligated to do under the 120-year rule. In her third amended affidavit, FOIA officer Wiggins finally admitted that she never even looked at the paper records and she only searched for Numident, which is not what was requested. Numident is a computer file. 120-year rule specifically states that SSA has to provide the SS5, a copy of the original application, not Numident. Why, according to the 120-year rule, the SSA is supposed to provide a certified copy of the SS5 and not the computer record, Numident? As information was entered in the computer record, often errors are made, and the computer record is not reliable. 2. Numident is not the best evidence. Violates best evidence rule, as SS5, the actual paper record, is the best evidence. 3. Original SS5 contains the signature of the applicant, and forensic document expert can examine whether the document contains ink and paper similar to the other documents created at the same time, can identify forgery. Numident is a computer record that can easily be changed. There were instances of intentional falsification of the computer files by corrupt employees. Plaintiff Taitz believes that falsification of the Numident of the SSA computer record of SSN 042684425 of Harry Bonnell was committed by Harry C. Ballantyne, former actuary of the Social Security Administration. As Taitz uncovered that at some point Barack Obama used the Social Security number of Lucille Ballantyne, deceased mother of Harry C. Bonnell. Deceased mother of Harry C. Ballantyne. See ECF 20, affidavit of licensed investigator Susan Daniels. In 1976-1977, there were changes in the SSA rules, where people who did not use SS numbers before, such as housewives or people working for cash, like Harry Bonnell, had to obtain their own numbers in order to get benefits, and the numbers had to be cross-checked with the death indexes. At that point, the SSN of deceased Lucille Ballantyne could no longer be used, and the SSN 042684425 of Harry Bonnell was unlawfully appropriated, stolen by Barack Obama after an employee of the SSA, believed to be Harry Ballantyne, made the change in the electronic record. So, according to Wiggins' own affidavit, she never looked at the SS5 original paper applications, which are stored by the SSA, in which she was obligated to search based on FOIA request and under 120-year rule. As such, a motion for MSJ for defense has to be denied. Motion for MSJ for the plaintiff has to be granted, as there is no triable issue of fact of law. Wiggins knew that she was required to pull and copy the original application, SS5 0426844425, which was filed right after 0426844424. SS5 of deceased Thomas Wood, Exhibit 2. She never did it, and the court has no other choice but to grant the plaintiff a motion for summary judgment. Further, as far as Numident is concerned, third amended affidavit of Wiggins is not truthful as well. As she herself found the Numident for Harry Bunnell as shown in her own letter of November 16, 2012, Exhibit 1, which she authenticated in her prior second amended affidavit. In her second amended affidavit, which Wiggins submitted to with her reply to opposition to motion to dismiss first amended complaint, Wiggins claimed that her November 16, 2012 letter, which she submitted to where she admitted to having the records of Bunnell, was sent after she only searched by the social security number and did not look at the name of the subject of the search. This statement was not true as well, as A. November 16, 2012 letter from Wiggins, reference number S9HA17967, does not state this letter is in response to your internet request for Numident for social security number 0426844425. No, her own letter starts with words. This letter is in response to your internet Numident request for Mr. Harry Bunnell. The Privacy Act of 1974, 5 U.S.C. 552 restricts disclosure of the information that you requested. Emphasis added. So Wiggins not only authenticated her letter, but in her letter she admitted that she looked for a record under the name Harry Bunnell, not under a specific social security number. B. Response by Wiggins is not truthful, not credible, and not even plausible, as according to 120-year rule, SSA is not allowed to look only at the social security number in the Numident search. SSA is obligated to look at the name and date of birth of the subject of the search, as SSA is obligated to provide the SS5 of individuals who are 120-year-old or older and are not allowed to use a privacy exemption. So not only Wiggins never searched the original applications, the original paper records, as she was required based on FOIA request on 120-year rule. She also was not truthful in regards to her search of the electronic database Numident. So, what was Don Wiggins supposed to do? Wiggins was obligated to make a minimum effort of going to the vault of the original vital records of the SSA, specifically the area of the SS5, starting with 042, which is assigned to applications from the state of Connecticut, and pulling the SS5 application for 0426844425, which is filed right after the SS5 for 0426844424 for the deceased Thomas Wood. See Exhibit 1, SS5 for Thomas Wood, which is filed right before the SS5 for 0426844424 for Harry Harrison Bunnell. My caveat, Don Wiggins is an attorney. I mean, how hard it is for an attorney to just get a piece of paper with the number ending by 4425, which is filed right after 4424. It's unbelievable that she could not find it. So Wiggins is a licensed attorney. She knew the difference between SS5 and Numident. She knew that she was requested to provide SS5, not Numident. She never did what she was obligated to do. Taitz requested the SS5, which is the original application for Social Security number. SS5 contains the name and the actual signature of the applicant. The forensic document expert can compare SS5 for Bunnell and SS5s that were issued before and after for authenticity of paper, ink, sequence, stamp, and so on. Numident is a computer printout. So I'm providing a little bit more information on this issue, and then the next cause of action deals with the fact that defense did not deny and therefore admit that it violated Rule 5 USC 552 and never responded to August 8th FOIA request submitted by Taitz. Further on, which is extremely important, defense did not oppose plaintiff's petition under 18 U.S.C. 332, and the court should grant as unopposed request under 18 U.S.C. 3332 for the Honorable Court to present evidence to the federal grand jury or grant the plaintiff an extra later status to step in the shoes of the Assistant U.S. Attorney and present evidence of offenses against the criminal laws of the United States alleged to have been committed within the District of Maryland. Since the defense did not oppose this petition, plaintiff is seeking to grant it under MSJ as unopposed. 18 U.S.C. 332 states, it shall be the duty of each such grand jury impaneled within any judicial district to inquire into offenses against the criminal laws of the United States alleged to have been committed within the district. Such alleged offenses may be brought to the attention of the grand jury by the court, meaning by the judge, or by any attorney appearing on behalf of the United States for the presentation of evidence. Any such attorney receiving information concerning such an alleged offense from any other person shall, if requested by such other person, inform the grand jury of such alleged offense, the identity of such other person, and such attorney's action or recommendation. 18 U.S.C. 3332A. And here are the offenses and evidence that was not disputed by the U.S. Attorney representing Social Security Administration. In this case, they did not provide any opposition. First, plaintiff provided this court with a sworn affidavit of investigator and debt collector Albert Hendershot, ECF 13-2, pages 1 through 10, that according to Maryland's information systems, two individuals used Social Security number 042684425, Harry J. Bonnell and Barack Obama. 2. On April 15, 2010, at 11:29 a.m., Barack Obama posted his 2009 tax returns online, an official White House website, whitehouse.gov. He did not flatten the PDF file, and the full unredacted Social Security number, which he used in his tax return, became available to the public. About 3 hours later, Mr. Obama removed the file, redacted and flattened it. However, by that time it was too late, and thousands of individuals got the full unredacted Social Security number used by Obama. 3. Subsequent checks through E-Verify and SSNVS, two agencies set by the U.S. government to check for unlawful use of Social Security numbers which are stolen or otherwise unlawfully used by illegal aliens and others, showed that Obama failed both E-Verify and SSNVS, and he is using a Social Security number which was never assigned to Barack Obama. 4. On December 23, 2013, it was announced by Barack Obama that he signed up for Affordable Care Act, ACA, Obamacare. 5. Plaintiff Taitz immediately published an open criminal complaint and demand for information sent to HHS demanding an explanation. How could Obama sign up for ACA with a Social Security number which failed E-Verify? And what safeguards are there in place to make sure illegal aliens and other individuals with stolen SSNs do not sign up for ACA? Within hours, White House announced that Barack Obama was not able to sign up for ACA Obamacare using the online website because the system could not verify his identity, and his aide had to submit Obama's application in person. 12/23/2013 report by Fox News Network White House correspondent Ed Henry. We learned today from the White House. Initially, they said he signed up for what they called a bronze plan, paying about $400 a month in premiums. But then they came back to us and said, wait, he didn't actually enroll. Healthcare.gov could not actually verify his identity, oddly enough. Plaintiff Taitz sought from SS5 of Harrison Bonnell. However, SSA, by and through its employees, FOIA Officer Don Wiggins engaged in obfuscation of records and obstruction of justice. As shown in this complaint, Wiggins repeatedly wrongfully withheld aforementioned application in order to cover up the fact that Barack Obama has committed massive fraud and has stolen the franchise of the U.S. president using a stolen Social Security number and fabricated IDs. 8. Wiggins and possibly defendant acting Commission of Social Security Administration Caroline Colvin acted in concert with a number of other individuals in a RICO conspiracy, racketeering influence corrupt organization to defraud the United States of America and aid and abet Barry Barack Soybarka, aka Barry Barack Soetoro, aka Barry Barack Obama, in stealing 2008 and 2012 presidential election, stealing the franchise of the U.S. presidency, cover-up and obstruction of justice in cover-up of stolen and fabricated IDs used by Obama. 9. Loretta Fuddy, Director of Health Department of the state of Hawaii, was complicit with Barack Obama, Don Wiggins, and others by writing a letter to the White House on April 25, 2011, and certifying a flagrant forgery as a true and correct birth certificate for Barack Obama. On April 8, 2011, Taitz appeared at the Health Department of Hawaii with 2 experts and a subpoena from the U.S. District Court for the District of Hawaii, ordering Fuddy to provide for examination the original 1961 birth certificate for Barack Obama, allegedly on file in the Health Department for the state of Hawaii. Taitz was greeted by Deputy Director Keith Yamamoto, who advised Taitz that Fuddy will not comply with the subpoena and will not produce the original wet ink birth certificate for Barack Obama. 10. On December 11 at 5 a.m. Pacific Standard Time, 3 a.m. Hawaiian time, Taitz posted a press release advising the public that there is evidence of forgery in the controlled Hawaiian birth certificate of Johanna Ani Randolph, and that it was found that Fuddy was defrauding the public, claiming that Obama's alleged copy of the alleged long-form birth certificate was released as a special exception for Obama as a president. As Taitz found that other long-form birth certificates released by Fuddy at the same time as she released Obama's long-form birth certificate. 15 hours later, around 6 p.m. Hawaiian time, it was announced the Director of Health, Fuddy, died, being the only victim of an emergency water landing of Cessna Caravan plane of Makani era. Fuddy died under suspicious circumstances amidst conflicting reports. Airplane crash and death of Fuddy are still being investigated by the Maui County, Hawaii Police Department and NTSB. According to the fire department, Fuddy's body was found in the fuselage of the plane. This report was made a full week before the plane was recovered and anyone knew what was in the fuselage of the plane. According to the reports of other passengers, such as C. Philip Holston and Captain Clyde Kawasaki, Fuddy did not remain in the fuselage of the plane, but got out, was wearing her life vest, and together with other passengers was waiting to be lifted by a helicopter. Both Holston and Kawasaki stated that they were shocked by the announcement of her death. All other passengers and pilot got out of the plane alive, had life vests, and were awaiting to be lifted by helicopter. Similarly, in 2008, it was reported that Lieutenant, sick, not a title but unusual first name, Quarles Harris, who, according to Washington Times, was cooperating with the FBI in relation to the reported breach of Obama's passport records, was found assassinated in his car. No arrests were made in this case since 2008. Salaya Soba, who resided with Obama's mother and stepfather in Indonesia, and whose story was different from Obama's official life story, as according to her, Obama did not come to Indonesia together with his mother, but rather came sometime later. Salaya Soba was found dead shortly before scheduled trip of Obama to Indonesia. She was healthy until her untimely death at the age of 52. Soba's story is supported by Scott Inoue, former Obama's classmate in elementary school in Hawaii. According to Inoue, Obama did not go to Indonesia in 1967, but rather lived in Hawaii until 1969. Inoue provided a picture of himself and Obama together in 1969. This shows a discrepancy with Obama's school records from Assis Elementary School in Indonesia, where Obama was a student from 1967 through 1969 and went by last name Suetoro, his stepfather's last name, citizenship Indonesian, religion Islam. This discrepancy shows that for a period of 2 years, there were 2 separate individuals, Barry Obama, who lived in Hawaii in 1967 through 1969 and went to a Noelani school in Honolulu, Hawaii, together with Scott Inoue, and a completely different person, Barry Suetoro, who lived in Indonesia in 1967 to 1969 and was a student in a sister school in Jakarta, Indonesia. In 1969, Barry Obama went to Indonesia And one of these two young men came back to the United States in 1961. Taitz believes that the person who came back is Barry Soetoro, not Barry Obama. All individuals who knew circumstances of Obama's trip to Indonesia died untimely death. His mother, father, stepfather, grandmother, 2 days before the election, grandfather, stepbrother, and former foster child of Andana and Lola Soetoro, Salia Soetoro Soba. Obama continued with egregious identity theft upon his application as an attorney to Illinois State Bar. Attached exhibit, Obama's application shows further fraud. On application, he is asked whether he used other names, and he put down none, even though his official school records from Indonesia show him using last name Soetoro, and his mother's passport shows him using last name Soebarka. When Taitz contacted Illinois Bar and complained that Obama is hiding his identity under different last names, Obama withdrew from the bar, and the bar responded that they no longer have jurisdiction. Bar applications are done under oath. Hiding one's identity under two different last names represents 2 felony counts of perjury and fraud, and applying to become an officer of the court while hiding 2 identities. This fact alone justifies referral of the case by this court to the federal grand jury for criminal investigation and prosecution, as we have an individual holding a position of the U.S. president while hiding prior identities. The defense did not deny any of the above facts, and the court should find those facts to be admitted by the defense and basis for referral by this court to the federal grand jury. Alternatively, pursuant to precedent of in the matter in regarding grand jury application number 85, civil case 2235 of U.S. District Court for the Southern District of New York, this court should issue a writ of mandamus to the U.S. Attorney for the District of Maryland to present to the federal grand jury evidence of violations against the criminal laws of the United States, as described in the Second Amended Complaint and uncontroverted by the defense. Refusal to provide SS5 for Bonnell is consistent with the modus operandi of unjustified refusal to release existing records, obstruction of justice, and lying to petitioners and courts, which was observed in regards to other records of Obama, as well as a record of lying to court by federal employees, which was noted in Muslim Council versus FBI 07-1088, and for which DOJ was sanctioned by the federal court. In the precedent case of Islamic Shura Council of Southern California, et al. Versus FBI, U.S. District Court Judge Cormac Carney sanctioned the Department of Justice in order to pay plaintiffs' attorney's fees due to a pattern of lying and stating to the court and plaintiffs that documents requested through FOIA did not exist, while those documents actually existed, and the agency obstructed justice. Department of Justice tried to justify lying using a memorandum by Attorney General. In December of 1987, due to concerns of national security, U.S. Attorney General Edwin Meese issued a memorandum for the executive departments and agencies concerning the law enforcement amendments to the Freedom of Information Act, 5 U.S.C. 552, enacted as the Freedom of Information Act of 1986. There is more information on this. In 2011, Attorney General Eric Holder issued 28 CFR Part 16 relating to Freedom of Information Act regulations. It stated, number 2, when a component applies an exclusion to exclude records from the requirement of the FOIA pursuant to 5 U.S.C. 552, the component utilizing the exclusion will respond to the request as if the excluded document did not exist. This response should not differ in wording from any other response given by the component. So in this new 2011 proposed rule, Attorney General of the United States is coaching agencies to lie to the public and to the court and claim that the documents do not exist while they know that the documents exist. Holder tried to justify this by seeking to codify, to legalize an ongoing practice, which is going back to aforementioned memorandum by A.G. Meese. So, Aforementioned memorandums and attached order by Judge Cormac Carney of the U.S. District Court for the Southern District of California show that this is an ongoing practice of the federal agencies lying to the public and the judges and claiming not to have documents that they actually have. Ms. sought this practice in the interest of national security. However, the court found no justification for such lying. And here's from Judge Carney. Despite its arguments to the contrary, the government's deception of the court was without any factual or legal basis and simply wrong. When the executive branch provides a court with misinformation and it impermissibly undermines the judiciary's authority to say what the law is. Marbury 5 U.S. At 177. See also Federalist Papers, number 78, Alexander Hamilton. There is no liberty if the power of judging be not separate from the legislative and executive powers. United States v. Nixon. The very integrity of the judicial system and public confidence in the system depend on full disclosure of all the facts. What the court previously stated in its amended order bears repeating. The government's duty of honesty to the court can never be excused, no matter what the circumstance. The court is charged with the humbling task of defending the Constitution and ensuring that the government does not falsely accuse people, needlessly invade their privacy, and wrongfully deprive them of their liberty. The court simply cannot perform this important task if the government lies to it. Deception perverts justice. Truth always promotes it. Something that we're not seeing in the past 5 years. Further, in Islamic Shura Council v. FBI, the defense could use the excuse of following the directions of the Attorney General Ms. in the interest of national security to fight Muslim terrorists. However, here the actions of the defense actually undermine the national security. Exhibits 1 through 23 submitted to this court with a Second Amendment complaint show that Barack Obama is a foreign citizen. He is listed in his school records from Indonesia as a citizen of Indonesia, religion Muslim, legal last name is the last name of his stepfather Suetoro. He's using a fabricated selective service registration, fabricated birth certificate, and a social security number 042-684-425, which according to E-Verify and SSNVS was never assigned to Obama, and according to Merlin's Information Systems database was assigned to Harry Bunnell. FOIA officer Wiggins knew that she had to pull the actual SS5 application for 042684425, which was filed right after the SS5 for 042684424 for the cis Thomas Wood. And she knew that not pulling the Social Security application and claiming that she has only electronic record numinant constituted a flagrant false statement. And this statement does not serve national security. It undermines national security. So conclusion, number 1, under 5 U.S.C. 552, this court should grant as unopposed petition for a certified copy of an original paper SS5 Social Security application of Harry Harrison Bunnell, which is stored in Social Security Administration headquarters and which is filed with Connecticut Social Security applications right after the SS5 042684424 of deceased Thomas Wood. 2. Due to refusal to cooperate by the defense due to the pattern of obstruction of justice violation of 5 U.S.C. 552 and 120-year rule of SSA, warrant for search and seizure of the original paper SS5 application 042684425 of Harry Bunnell should be issued to the U.S. Marshal. 3. This court should order tracing of any and all changes to the computer file of the SSN 042684425 with electronic ID stamps of each and every employee who changed the file. 4. Under 8 U.S.C. 3332, this court should forward to the federal grand jury for the District of Maryland evidence of criminal offenses against the criminal laws of the United States to be investigated by the federal grand jury. 5 under 18 U.S.C. 3332 and per precedent of in the matter of in regarding grand jury application number 85 civil 2235 VLB USDC for the Southern District of New York. This court should issue a writ of mandamus for the U.S. Attorney to forward to the federal grand jury evidence of violations of criminal laws of the United States, which was submitted in this case. Respectfully submitted, Dr. Orly Taitz, Esquire, plaintiff pro se in this case, February 18th, 2014. So I'm expecting a decision for the presiding judge. It's Judge Ellen Lipton Hollander to come shortly, and hopefully she will respond and will issue a decision in favor of me, the plaintiff, and will order the Social Security Administration to produce that application of a Social Security number of Harry Bonnell, which is fraudulently used by Obama, and hopefully Obama forgery gate will unravel very quickly from this point. Thank you very much, and I'm thanking everybody for their support and their prayers and donations, and hopefully together we'll be able to end this nightmare and this fraud very quickly. Thank you.